Right here. Excellent. Good evening, everyone. Thank you so much for coming this evening. We are going to go ahead and move along, if you don't mind. We will commit to get you out on time, and we also anticipate having a 5-minute break in here. So we have to do the full 2 hours, so it'll be 8:05 when we get finished up. My name is Shannon Chaffin. I'm from Alshire & Winder. This is John Fox. He's also from Alshire & Winder. And we will be stepping you through the lovely intricacies of AB 1234 this evening, along with our conflicts of interest. This has been noticed as a public meeting for all boards, in case some of you get to the Brown Act compliance section and then wonder, hey, has this been noticed? This indeed has been noticed. And since it's a workshop, we don't necessarily need any sort of to have to provide for public commentary, but it depends. We may get there if we have to. The one thing I'd ask you is you don't have to shut off your phones if you don't want to, but I do reserve the right to answer them for you if they ring during the proceedings, and I get to choose how to respond, so that can be fun in itself. So if you do have your phones and don't want me answering them for you, please feel free to silence them at this time. We'll jump right in with regards to a summary of today's training. Why are we here? It's required by law. It's required by AB 1234. AB 1234 is codified in the government code. It's also the fiduciary duty of each member of a board or agency. And we have 4 parts that we're going to be covering today. The first part is laws related to personal financial gain. The second part is laws related to restrictions on perks of the office. The third part is laws related to government transparency. And part 4 is laws related to fair process. So, who must attend? If you are an elected official, you must attend. If you have been appointed members of a board of commission who receive compensation for your service or are reimbursed for expenses, you must attend. And employees who file statements of economic interest. So if you filed a Form 700, you are probably here tonight. So what are the requirements of AB 1234? AB 1234 requires training of public officials about core laws and ethics. And in fact, thank you very much. Core laws and ethics. And the interesting thing is if we cover the ethics, please don't think that we're trying to impose on you our own brand of ethics as to what we think are the minimum requirements that public officials and staff should have. These are requirements of the law that we're covering. So we'll also be trying to teach ethics as part of the law process. I still have a question as to whether or not you can actually teach someone ethics, but we're going to go as to the basic standards anyway. And the training is required within 1 year of taking office, and then after that you have training every 2 years. Now, one of the challenges that we have with that is the law changes every year. The legislature adds more and more things. As more stuff comes along, they change more things. What that means is after about a year, your training compliance is probably going to be out because there's going to be changes. So just keep in mind as you go through and you start to hear things as the coming years of saying, hey, there's been changes to the law. Don't be surprised if there have been changes. And of course, we're also going to cover public record items. And whether or not you've taken the training is a matter of public record as well. So our learning objectives today are, of course, to do compliance with AB 1234 and to review the core laws so as to know when to ask questions. Do not be surprised as you go through here. I'm sure some of you have gone through this process before. It is very complicated. There are a lot of different laws. There are a lot of different areas. There's a lot of different requirements. Some requirements have exceptions to the requirements, unless there's an exception to the exception, and it gets all tangled up and it's all factually intense. Our goal is not to teach you every single one of those things today. Our goal is to teach you the flags. So when some time comes along and some situation comes up, something happens, and you can say to yourself, that guy that told me that he was going to answer my cell phone, he said something about this. And then you can go and follow up with your agency attorney and other individuals in order to find out how to handle that particular situation. We're also going to be doing a discussion of ethic principles beyond the law. We also want to alert public officials as to financial interests, relationships, and activities that may be prohibited or which may trigger disclosure or disqualification, and also to advise public officials of the consequences of violating ethics laws. Again, this is a very complex issue of law. And one of the most difficult things that we have as attorneys to various agencies around the state is when a council member or board member comes up mere moments before voting and says, hey, you know, I'm not sure if I have a conflict or not. And while we're very happy to have people approach us as to these things, our advice is to, in Chicago, it's vote early, vote often. Here it's disclose early, disclose often. Contact your legal services as early as you can. A lot of these issues are very factually determinative because if you wait to the last moment, what's likely to happen is the attorney is likely to give very conservative advice. Because there's so many facts, it's almost impossible to determine which factual situations or exceptions to the exceptions may apply within a few minutes' time. So, ethics and laws. The Attorney General's Office and the Fair Political Practices Commission require that training include a discussion of the values and explanation of importance of avoiding the appearance of impropriety. And as you know, the appearance of impropriety means it shouldn't look bad. Does it pass the smell test? Ethics laws are merely set a minimum standards for conduct, and what we typically see is the legal requirements set a floor here, and then the ethical requirements are above what the legal requirements are. So just because you've complied with the law doesn't mean that you've necessarily complied with the ethical requirements. And the interesting thing about ethical requirements is everybody has a different idea as to what's ethical and what's not. So the state has kind of set parameters or guidelines as to what is ethical for the purposes of public officials. And it's in a lot of ways it's doing about what ought to be done rather than just what's required. So what are the universal ethical values required to be taught as part of AB 1234? Well, there's 4 of them. There's trustworthiness, respect, fairness, and responsibility. And the reason why they chose these 4 qualifications is they promote public trust in the government. So what do these values actually mean in the context of a public servant? When the rubber hits the road and you're actually in a day-to-day situation, what does it mean? Well, let's start with trustworthiness. And that focuses on services to your community, truthfulness to your colleagues, staff, and the public, not using your position for personal gain. That's a really big one. Keeping promises, not accepting gifts or other special consideration, not knowingly using false or inaccurate information. You can be wrong, just don't be intentionally wrong. The second item is respect. And it really, we see a lot of different boards and commissions that we advise. And one of the things that you can tell are commissioners and board members that actually apply these principles and how they move forward with their meetings and how they interact. And it makes a big difference if these are applied in the functioning of government. And one of the things is debating courteously, avoiding personal attacks, listening. That's really hard for me sometimes. I'm Irish, I talk a lot, that's what we do in my family, but listening is a very important part. Preparing for meetings, including others in the public and decision-making process, and be approachable and open-minded. Then there's also the issue of fairness, and that is to base the decisions on the merits and the facts of the situation. Following the procedures, making sure everybody receives the appropriate notice, receives the opportunity to be heard as part of the process. Keeping an open mind and considerations, being consistent, being impartial, supporting the public's right to know, not trying to hide the ball, and recusing yourself when it's necessary. And then finally, responsibility. And this goes back to basically being responsible for the public's resources. Promote the efficient use of agency resources. When there have been mistakes, admit the mistakes, fix the mistakes, and then move on. Represent the agency's position even when you personally agree with it. Sometimes board members will outvote you in your position. You are perfectly entitled to your position, but once the board has made a decision, the decision should not be sabotaged by board members who don't necessarily agree with it or city council members. So there is that balance there. Safeguard confidential information. That one's near and dear to my heart just because I've run into the issues with it, so I'll actually say it a second time. Please safeguard your confidential information. It makes my life so much easier, and it saves a lot of resources for the agency as well. Do not make promises that are unrealistic, and do not use information for personal advantage. I'm going to turn the time over now to John Fox, and he'll teach the next section.
All right, so the next section is going to be a section discussing the laws regarding financial gain. So we're going to touch on the criminal laws, the conflicts of interest under the Political Reform Act, conflict of interest in city contracts, conflicts of interest and campaign contributions, and conflicts of interest after leaving office. So what are the purpose of these laws? Well, public officials should make decisions based solely in the public's interest. Prospect of financial gain or avoidance of detriment to personal interests must not affect the decision-making process. So the first area we're going to talk about is in the criminal context, and that's bribery. What is it? Well, bribery is requesting, receiving, or agreeing to receive money or other advantages in exchange for an official vote, opinion, or action. It's a crime. It's punishable by spending time in state prison, and you are disqualified from public office or public employment, not just for a year or 2 years or 5 years, but for life. So the consequences of bribery is significant. In fact, it says that a public official in the statute, a public official that is found guilty of bribery forfeits his or her office, employment, or appointment, and is forever disqualified from holding any office, employment, or appointment in the state. So, bribery isn't just about exchanging money. It's also dealing with items of value. So what might those be? Well, they could be admissions to events or the like. Discounts. You receive a discount that other people do not receive. An example that I have given is, let's say someone wants to develop in the city of Morro Bay a 10-unit condominium complex. And the developer says to a council member or a planning commissioner, if you support me on this project, I'll give you a 40% discount on the condo if you want to buy a condo in our complex. Well, that would be a discount that would be provided to an individual in exchange for a vote, and that would constitute a bribe. You know, trips, other types of privileges, nice meals, things like that. Contracts. Let's say in your day job, maybe you serve as a planning commissioner, but in your day job you serve, you're an architect. And someone comes and says, you know, if you support this project, you know, there's a really great architectural contract out there for you that we'll send your way if we get the support from you that we need on this particular project. Preferential treatment. The other one is vote trading, and this is something that I don't know a lot of people think about, because you think the political process is sort of a horse trading sort of thing. But if, for instance, one council member says, if you support me on this particular item, I'll support you on another item, that direct kind of trade for a vote would constitute a bribe. And it's something you need to be very careful about when you're in these types of positions, because obviously you're always looking, if you're a council member or a public official, you're looking for people to support the things that you find important. And so you need to find that balance as to how do you gain that support and make sure that you don't venture into the area of what could be considered a bribe. Future school tuition and benefits, agency, position, or employment. So we've talked about the state definition, and here's the federal definition. Directly or indirectly gives, offers, or promises anything of value, and demands, seeks, receives, accepts, or agrees to accept anything of value. And what are the consequences? Fines of 3 times the value of the bribe, 15 years in prison, and the loss of office. And again, that is for life. So in summary, when we're dealing with bribery, the consequences are pretty significant. Jail time, loss of office, unemployment, and of course those are the legal consequences, but then you have the other types of consequences such as public embarrassment and the impacts that such a conviction would have on your family, and just how demoralizing that could be to your family. So next, after bribery, we're going to talk about the Political Reform Act, and this deals with financial conflicts of interest. And so we're going to deal with the general financial conflicts of interest, and then Shannon's going to come back and talk about financial interests in public contracts. And those are called Government Code 1090 issues. And there's some important distinctions between the two. The Political Reform Act is administered by the Fair Political Practices Commission. It is the most detailed disclosure law in the nation. And as Shannon said earlier, because it is so detailed and so fact-intensive and there's so many regulations, it's a challenge in order to make sure that you are in compliance with these financial interest statutes. And so the more time that you provide your attorney to evaluate potential conflicts of interest, the better, so we can get the best result. Also, the Fair Political Practices Commission plays an important role because they will issue official opinion letters, and under certain circumstances, you can rely upon those opinion letters in moving forward on a matter for which you received an opinion on a financial conflict of interest. The laws are amended every year since enactment. Requires disclosure and reporting, and requires adoption of a conflict of interest code by public agencies. And for the city of Morro Bay, it's my understanding that on tomorrow night's agenda is the potential adoption of a resolution to update the city's conflict of interest code to make sure that all the new positions and movement and the like have been accounted for in the conflict of interest code. So when we're dealing with a regular financial conflict of interest, what we're talking about are two things. We're talking about either disqualification and disclosure. So disclosure is primarily when you're providing your economic interests and you provide the disclosure of those in the statement of economic interests. And then disqualification occurs is when those economic interests are affected by the decisions you make. So what triggers disqualification and disclosure? Well, first of all, if you have a financial conflict of interest, that doesn't mean you're engaged in anything that's unlawful. Many people have financial conflicts of interest. If you own a piece of real property in a community, there's a potential that you may have a financial conflict of interest down the road if you're engaged in or participating in a decision regarding property in the vicinity of the property you own. So it's not that it's unlawful to have a financial conflict of interest. The problem occurs is when you don't handle the financial conflict of interest correctly. So it's a condition that triggers certain requirements. Action or inaction may be unlawful. So, what is the basic prohibition under the Political Reform Act? The Political Reform Act prohibits a public official from making, participating in, or in any way attempting to use his or her official position to influence a governmental decision in which he or she has a financial interest. If a public official has a conflicting financial interest, he or she must recuse self and not participate in the matter. So here's kind of the standard, or this is the standard that is utilized in determining whether or not a public official has a conflicting financial interest. A public official has a conflict of interest if the decision will have a reasonably foreseeable material financial effect on his or her economic interests or that of an immediate family member, unless, and there's two exceptions, one is the effect on that individual is indistinguishable from the effect on the public generally, or the official's participation is legally required. And we'll talk briefly about those two exceptions. For purposes of this code, the Political Reform Act, the term immediate family means spouse and dependent children. It doesn't mean parents. It doesn't mean brother or sister. It doesn't mean your adult children necessarily. It's your dependent children. So when dealing with a potential financial conflict of interest situation, there are 4 questions that need to be asked. First, will you be participating in the decision? Does the decision, the second question is, does the decision affect your economic interests? Third, is the effect of the decision on your economic interest material? And does the decision affect your economic interests differently than the public generally? So let's start with the first question. Are you participating in, or influencing a governmental decision? So we've provided some examples here as to what would be considered making a decision, and that would include voting, appointing a person, or entering into a contract. Participating in the decision would be negotiations, research, investigations, and advice. So city staff often deals in the negotiation phase, research, trying to find the best the deal for the city on a particular issue. Influencing a decision would include contacting agency staff. So if a public official or a city council member contacts staff and says, hey, how's this project coming along? I'm really excited about it, and I really want to see this come to the council soon so that we can make a decision on it. That might be in the realm of what is called influencing the decision. Ministerial, secretarial, manual, or clerical work is not covered. So if you have a legal assistant or a secretary that's just basically doing that type of work, that would not fall within this category of making or participating or influencing a decision. Representing your personal interests, such as negotiating for your own salary, is also exempt from this definition. So we're briefly going to talk about some types of economic interests. So an investment of $2,000 or more in a business entity would generally be considered an interest in that entity. And it can include investments owned by spouse, dependent children, or trust, but not include bank accounts, mutual funds, money market funds, insurance policies, and government bonds. Another economic interest would be serve as an officer, director, or employee, or hold any business position in a business. A real property interest is an interest with a value of $2,000 or more. And then any source of income of more than $500 over the last 12 months. And then any source of gifts of $460 or more in the prior 12 months. And these gifts are from a single entity or individual. So not in total, but from a single entity or individual. So what is reasonably foreseeable mean? So reasonably foreseeable material financial effect on you or your immediate family that is distinguishable from the public generally. So this financial effect can either be an increase or a decrease. So sometimes you see questions from people saying, well, you know, if I vote this certain way on this item, or if I vote to approve this item, I'm actually going to be hurt financially by the decision. It doesn't matter. The effect can be a benefit or a detriment to you, but you can still have a financial conflict of interest. So what or who is involved in these types of decisions? A person or business entity that is a party to a proceeding. Your investment, income source, or gift is the subject of the decision. You are employed by or officer or partner in the business that is the subject of the decision. Any financial effect on your personal finance or of your immediate family's personal finances, or you own real property within 500 feet of the subject of the decision. So Shannon had mentioned earlier that the laws regarding conflicts of interest change annually. Well, in 2014, there were some significant changes in the laws, and one was they modified the traditional 500-foot rule. And many of you are probably aware of the presumption that if you own property within 500 feet of the location upon which a decision is to be made, you are presumed to have a conflict of interest. And the only way in the past to rebut that presumption is to basically establish that the decision would have absolutely no change in your financial condition, not a penny either way. It was a very strict standard to overcome that presumption. Well, the Fair Political Practices Commission decided that that was probably a bit too strict. So they've changed that one penny rule to this new language. So you do not have a financial conflict of interest, even if you have property within 500 feet of the location of a decision, if you can determine that there's no reasonably foreseeable, measurable impact on the official's property. So that's the good news. They've kind of relaxed that standard, but the one proviso is that the only person that can make the decision as to whether or not there's no reasonably foreseeable, measurable impact on the official's property is the Fair Political Practices Commission. So what that means is that if you are placed in that situation and you want to participate and vote on a decision, you need to request the Fair Political Practices Commission issue an opinion on this item. So let's say you own property beyond 500 feet from the location of the decision. Are you home free at that point? Well, the answer is no, because they've also modified the standard by determining whether or not you have a financial conflict of interest. So even with property that is beyond 500 feet, the official must consider whether a reasonably prudent person using due care and consideration would believe the governmental decision was of such a nature that its reasonably foreseeable effect would influence the market value of the official's property. So one potential example of this is, let's say you own a piece of property that has a beautiful view of the ocean, unobstructed view of the ocean. But there's another piece of property, maybe 700, 800, or 1,000 feet in between, ahead of you, and between you and your beautiful view of the ocean. And someone comes to the city and says, you know what, I want to build a 5-story condominium complex which would block your unobstructed view of the ocean. Well, I think a good case can be made that that would have potentially have a material financial effect on your property if that is approved. And so that would probably create a conflict of interest. Or let's say another commercial project is going in, down the street from where you live, and it's going to generate a whole bunch of new traffic on your street. Again, that would be another example where it could potentially affect the value of your property and it'd have a material financial effect on you. So there are also new rules regarding leasehold interest. Let's say you don't actually own real property, but you have a leasehold interest in a piece of property, and you could be dealing with situations where a city decision would change the termination date of a lease, increase or decrease in potential rental value of property, increase or decrease in potential rental value, and the official has the right to sublease, change in official's actual or legal allowable use of the property, and that might be in the context of perhaps rezoning of the property or a change in the general planned land use element to change the potential planned land use that either would allow you to do more with your leased property or less, impact on official use or engagement of the property. So the next exception is, let's say you do have a financial conflict of interest, and you say, you know what, I'm going to have to recuse myself from participating in this decision. There is an exception when you would be legally required to participate in the decision, even if you have the financial conflict of interest. And the classic case where this comes up is if you have a city council of 5 members and a decision, a project or an item comes before the city council, and 3 of the council members disclose that they have financial conflicts of interest and they will not be able to participate in the decision. So, so in that situation, you had a 5-member council, you've lost 3, you have 2 left, you don't have a quorum. So you don't have a quorum now, and you'll never have a quorum because they will always have this financial conflict of interest. So in that context, that would be a circumstance where one of them would be legally required to participate in the decision. And how it is determined which one is going to participate is usually through the use of the drawing of lots or pulling numbers out of a bag or something that's sort of considered random or by chance, and that individual would then participate in the decision. But the situation where a person is not legally required to participate is, let's say, that same situation where you have the project, but in this case, one of the council members who is not present that night. They can't be there. So now you're down to 4. And then in this case, you only have 2 council members that have a financial conflict of interest. So they have to recuse themselves. So now you don't have a quorum for that meeting to decide anything on that particular issue. Well, this would not be a legally required to participate situation, because if you continued the matter to the next meeting and made sure that that other council member that did not have a conflict of interest but who couldn't make the first meeting was there, then you potentially have a quorum that could make a decision. So that's kind of the distinction between those 2 situations. And it's back to Shannon.
We can do the high five thing. I'm fine with that. Maybe a fist bump or something. So what happens? You have a conflict of interest. Now what? What do you do? Well, when you have a conflict of interest, it means that the public official is prohibited from participating in a decision being made by the agency. And this disqualification process applies to the vote and to the entire process leading up to the vote. There's kind of this concept out there sometimes, some people are under a misunderstanding that, gee, I have a disqualification, I'll just wait and maybe participate in some of the process, and then when it comes time to vote, I'll recuse myself. Well, that's not what the law requires. Instead, for what they call the leave the room requirement for the vote, not voting is not enough. Just to say I'm not voting is not enough. The law is you may not make, participate in, or influence any decision that will have a foreseeable and material financial effect on you, your immediate family, or any of your economic interests. And the influence part is where a lot of people run afoul of things. You don't have to say anything to influence someone. I can tell you personally, from having been in a room with my mother sitting there when I was a child, that I started to do something and my mother didn't have to say a word. She just raised her eyebrow or gave me that particular look, and I knew what direction she wanted me to go. Well, in some sort of ways, that whole influencing process can also be applied. So even though you may have a conflict of interest and you decide to go to a staff meeting where they're discussing something in which you may be financially interested in, and you don't say anything, that could still be considered to be influencing a decision. So our recommendation is do not be involved at any part of the process on it. It's not just about leaving the room when it's time to vote. It's also about not participating in or influencing the process. Now, when we talk about the leave the room requirement for the vote, don't just get up and walk out, because people may not know what's going on there. The requirements are you need to publicly identify the financial interest or potential conflict of interest while at the meeting, such as, I own the business across the street, or I own the lot that will be blocked by this 5-story condominium if it's built. The second one is do not attempt to influence the decision in any way, including pre-meeting discussions with staff or colleagues. Again, the word influence is in there. Influence in any way. They've really tried to encompass all possible situations in the scenario. Now, sometimes you'll see items that aren't regular agenda items, but they're on the consent calendar. And as you know, on the consent calendar, they may have 2, 3, 5, or even 10 different items. And if you, as a decision-making official, a city council member, or as a board of supervisors member or an agency, see that you have a conflict of interest in one of those items, you can't just say, okay, I'm disclosing a conflict of interest in item number 7. I'm not going to be voting on it, but we're going to vote on all the other ones at the same time. That doesn't work. The process is you literally have to leave the room when the vote is taken on item number 7. So that item has to be pulled out. All the other consent items can be voted on simultaneously by one vote, and then you would disclose and actually leave the room so the rest of the members can vote on that remaining item. The only piece of advice I have for you that in these disclosing processes is to tell someone, remind them to bring you back in afterwards, because I've seen scenarios where somebody steps out of the room, they're not participating, they don't realize they've gone on to other agenda items for a while, and finally they're knocking at the door saying, is it safe to come in? So please, if you happen to notice, or if you're staff, please feel free to make sure that they can come in for the rest of it. Moving on to campaign contributions. These special conflict rules apply to proceedings on licenses, permits, and other entitlements. Licenses, permits, and other entitlements for use pending before certain state and local boards and agencies. Now, the basic prohibition is that covered officials, and you have to be a covered official, are prohibited from receiving or soliciting campaign contributions of more than $250 from parties or other financially interested person during the pendency of the proceeding and for 3 months after its conclusion. And if you do receive those contributions, or any covered official who has received more than $250 in campaign contributions in the 12 calendar months, and that includes from the time that the application is filed, coming forward, and the matter is being brought before the board, is required to disqualify themselves. Now here's something interesting. This doesn't apply to all public officials. So you can actually have a situation, for example, when it applies to planning commissioners, those who are sitting on the planning commission, may be prohibited from accepting these conflicts or these campaign contributions, but members of the city council are not. And we talk about how laws change a lot, and it's usually in response to things. And I think this might be one of those areas where the legislatures may say, well, hey, if you have a city council member who's running for a council seat and a planning commissioner who's running for the same council seat, why is this one disqualified but this one is not? So I could see those sorts of changes being made over time in this one as well. But if there is an issue regarding elected officials when they're not serving in their elected capacities, when they're being appointed as to other boards receiving campaign contributions. So if you start running into those situations, again, it's time to start asking your attorney, saying, hey, I've been appointed to be on LAFCO, and then now I'm getting a campaign contribution from one of the developers who wants to de-annex to someplace. That's the time to start asking these questions. And that should be annex, not de-annex. I'm sorry about that. Now, conflicts of interest under the PRA, what are the consequences? Well, again, you'll start to see this theme again and again and again and again. Fines, prosecution, and then you have the non-tangibles, loss of reputation, and family impacts. And I can tell you, as a person who advises a lot of different agencies and municipalities, the one thing I do not want to see is I don't want to see my municipality on the front page of the newspaper. And I definitely don't want to see a planning commissioner, a board member, or a mayor, or whoever the case is, with their face on it saying, so-and-so violated such and such principle. It's an absolutely devastating effect when you have these sorts of accusations being made, regardless whether or not it may have been legal or questionably legal. So please try to avoid those situations. It just ruins everyone's day. Now let's talk a little bit about interests and contracts. And the general rule is, if you have an interest, don't. That's an easy way of remembering it. A public official may not have a financial interest in any contract made with them in his or her official capacity, or a board or a body of which he or she is a member. And one of the things to remember is, if you're entering into a contract with your board or your agency, that's a big flag. And the other thing to remember is, in the state of California, it's not just written contracts. It can be some sort of oral agreement. So that widens it out as well. So be very, very careful. If you're ever starting to run into situations, that's a really big sign. And here's the other consideration. If one board member, if one board or agency member is financially interested in a board decision, then the entire agency is disqualified. The entire agency. You can't abstain or recuse. That's just not enough. And the reason is, this seems kind of harsh. Usually when I say this, everybody just kind of goes, well, why is that? And you will see this theme. They usually change the laws in response to stuff that happens. And what had been happening was what I call the wink, wink, nudge, nudge kind of way of doing business, where one person would say, I have a financial conflict of interest, and my contract here is coming up, I'll step out of the room, wink, wink, nudge, nudge, you guys know what to do. And then, of course, there would be a vote, and guess what? The absent council member or board member is awarded the contract, even though they weren't in the room. And so this law basically says we would rather err on the side of caution, that we ever get into these sorts of situations, we don't want it. And it comply in a way that you wouldn't think it would. For example, let's say I was a council member and I owned a Ford dealership. And my city wanted to update its police car fleet. And I said to them, listen, I will give you, not only will I give you literally the price that I buy these vehicles at, no profit whatsoever, I'll actually donate another 20% out of my pocket if you enter into a contract to buy these vehicles. Because I believe in police and protection and safety so much. Well, guess what? Can they approve that contract even though I'm losing money and doing it for the public good? No. If one board member is financially interested, even if it's a negative financial interest, even if you're losing money or being damaged, everybody's disqualified. So,
Can you tell us how they would award the contract? Who would award it?
They wouldn't, not to the Ford people. So here's the deal. If you own a business that does a lot of contract work with the city or municipality, don't run for public office unless you're willing to lose that contract, because they will not be doing business with you anymore in order to comply with the law. So just no police cars from that Ford dealership. They would actually have to go to another dealership. They'd have to go to Slow or someplace. They could go somewhere else, that's correct. They just can't be involved with that contract or that business because a council member is involved. even if it was an incredibly good deal, and even if it cost them 50, 60, or 70% more to go someplace else to pick up those vehicles. They would rather err on the side of caution and avoid the appearance of something going wrong than having these situations come up. But with every good law, there are exceptions. And then there's usually exceptions to those exceptions as well. But one of the exceptions, and they have a list of statutory exceptions, is public services generally provided on the same terms and conditions. Does everybody else have the same opportunity? Governmental salary, unless the contract is with your department, and a remote interest. And then there's a list of statutory exceptions, there's salary exceptions and certain procedures. But there's too many exceptions to really remember, but I think of this as the mutual fund exception. If you own mutual funds in McDonald's, and you're on the planning commission, or you're the staff member making a recommendation, planning commission, and something comes up with regards to a conditional use permit so that the McDonald's can be built on a certain lot, and somebody will jump up and say, I read your Form 700, I know you have mutual funds, and those mutual funds include investment in McDonald's. You are disqualified. You need to disqualify yourself under 1090. And the answer to that is probably not. And the reason is it's so remote. McDonald's is probably a multi-billion-dollar corporation at this point. And the amount of your investment, unless you are significantly more wealthy than I anticipate that the typical person on Planning Commission would be, won't have an impact. Whether or not that one restaurant is, if you own 1/1,000,000th of the total value of the shares, the impact of that one restaurant is so remote, it doesn't make a difference. However, if you own an interest in the franchise for that particular location, suddenly that factual distinction is different because it's that franchise that you have the financial interest in. So when you have that financial interest, that's no longer quite such a remote interest. So again, violations. I'm sure you guys are going to recognize some of these. One of the new ones on this one is the contract is voided. And you may have to disgorge any money that you received under that contract as well. And often it's a one-way disgorgement. The offending board member must resign from the board and or potentially or irrevocably renounce their interests unless there's an exception that applies. Staff members in violation must be screened from the board action. If you own McDonald's stock as part of a mutual fund and you're a staff member, probably a remote interest. If you have a business, if you went in, you loaned, you bought in with your brother who's doing the McDonald's franchise, and you're working on the application for the site plan or the CUP or whatever the case may be, that raises its own questions. So you must be screened from the board action. So if you're a department head and you know that one of your employees who's working on it and who's filed a Form 700, you may want to do the screening to make sure that the appropriate walls are raised. And violation is a felony that can result in imprisonment of the public official and fines. And a quick words on the difference between misdemeanors and felonies. Misdemeanors, up to a year. Felonies, over a year. And that's in jail versus prison. And because the law is always changing, again on January 1st, there's a new provision. It is now a felony to aid and abet a government official in violating conflict of interest contract laws. So, if you are a staff person assisting in helping a contract get awarded to a certain business and structuring things, or at least aiding and abetting that process, it's potentially a felony. If you are a city attorney who had a council member come up to him at the very last instant and said, is this okay? And then the city attorney said, I guess so, yeah, sure, or didn't say anything, could be aiding and abetting. So what we're going to see, I think, as a result of this law is, again, when I say consult early, consult often, you're going to see much more conservative advice being given by the city and board attorneys, especially for last-minute conflicts, because they don't want to be aiding and abetting. So they could be aiding and abetting. And instead what the remedy may be and your response may be, it may be, well, you either need to disqualify yourself, or if it's a contract, they may say, you may need to continue this item because there's so many factual scenarios and so many exceptions and so many exceptions to the exceptions, it's almost impossible to analyze them in such a short period of time, and the penalties are extremely severe if not. So you're going to see more continued items, and you're going to see these sorts of things unless there's an early consultation as part of the process. Now, I have a few case law examples because I know that's just what you really wanted tonight, and you're thinking, wow, if I could just have an attorney talk about cases, my life would be complete. I did not want to disappoint you. Just 3 brief cases. The first one basically says it doesn't matter if the contract is good for the public. It doesn't make a difference if the public is getting a good deal on these new police cruisers because I'm giving it to them at less than market value. Doesn't make a difference. Still a conflict if it's a contract. The other 2 cases, one deals with a sitting board member saying it can't be appointed as a general manager. As you know, when you appoint a general manager, you usually enter into some sort of employment contract. It's something you are interested in your own contract. And the last one was a council member appointed to the city manager was prosecuted. In that particular case, there was a 1-year prohibition against such appointments. The council member assisted and was able to vote on getting that removed, so she could then be appointed and be voted on her own agreement as the new city manager, and she was prosecuted criminally as a result of that.
And Shannon, just on the Chacon case, the defense of Ms. Chacon throughout the entire process is that she relied upon the advice of her city attorney, who had indicated that everything was okay and they were doing everything properly, and the court said, nope, too bad, so sad. You cannot rely upon the advice of the city attorney. You're personally responsible for that decision, and you will suffer the consequences. Well, at the time, the aiding and abetting wasn't a law. It just came into effect as of January 2015. So probably he was aiding and abetting in that particular circumstance because he was encouraging the entire process. So,
and that may be one reason why the new law went into effect. But I'd just be speculating. But often you have these situations come up. The legislature adds new laws because more laws make things easier. And I almost managed to say that with a straight face. Incompatible offices doctrine. We're going to jump into something just a little bit different here. And, often what happens is we see this doctrine involves when you have 2 political offices. And when sometimes political offices can be, at odds with each other. Sometimes the city and the county don't really mesh, or there may be conflicts between the 2, or even potential conflicts as to what, for like annexation before LAFCO, for example. The county may say no, the city may say yes, or the city may say no, and the county's like, well, you provide the services, you're going to be a better service provider. And these sorts of things have a potential for conflict. So what happens when somebody runs as a city council member and is elected to office and then runs for the board of supervisors and is elected to offices? They're wearing 2 hats. And as you know, sometimes the cities sue the counties sue the cities. They're involved in these confidential closed sessions as to what's going on and back and forth. It starts raising the issue of conflicts. And the general rule is you can't wear 2 hats. Pick a hat and stick with it. Only the law is going to pick a hat for you. If you have it, you have 2 hats, it's the second hat, no matter what. That means if you're a city council member and then you run for elected to a cemetery service district or something, I'm just picking an example, and it happens to be within the jurisdiction of the city, guess what? Congratulations. The city is going to now hold a special election probably for your now empty position. You can't wear both hats. So the penalty is automatic forfeiture of the first office when the second office is accepted. Now, this only applies to officials, elected officials, not employees. So you can work at the city as an elected official, and then you can also be, what was that? As an employee. Yeah, what did I say? Elected official. It's getting late already. Yes, you can work at the city as an employee and then also run for office elsewhere, even though it may be sometimes, like, again, the community service district for the cemetery may not necessarily get along with the city or the county, or however that's done. Prospective employers may not influence agency decisions when the interests of the prospective employer are at stake. When there's a negotiation or any arrangement concerning prospective employment with someone who has business before the agency. This is one of those situations that sometimes if you're working and you have your resume out or you're looking for another position, you've got to be careful if those applications are in front of you. So the law kind of looks at that and says, well, what's going on? How are you doing it? Are you making this decision based on the public good, or is it because they may be a potential employer for you? There's also what they call revolving door limitations. And basically there was a practice going on where a council member or a mayor would be elected and then they would term out, but you know what, during that 4-year term when they were out, they would be immediately appointed as like the city manager, or they would find a job representing people before the city council. And so the last day and the next day they'd come back and they'd say, hey, I'm the new lobbyist for ABC Group, you know, please award this contract or approve this permit for them. And the state legislator said, you know what, that just doesn't smell right. And so what we're going to do is for a period of 1 year after you've turned out of office, or whatever the case may be, elected officials and top-level managers, this includes department heads, cannot represent individuals or entities before their agencies. And the rule about that is the revolving door prohibition only applies if the former official receives compensation. So if you are a former official and you are the Department of Public Works, for example, and you have a paving company that you go in the next day and say, wow, this is a really great paving company, why don't you award the contract to them? They're really, really great, and by the way, I'm getting compensated for that. You're violating the law. If you decide to basically show up as a civilian and say, I've worked with these people previously, I'm not getting paid any money, but I think that they're their best choice, that's a different distinction. So, and the other thing to remember is the local agencies can adopt more restrictive provisions. So just because you complied with state law doesn't mean you complied with local law. And that's kind of tricky because you have local law, you have state law, you have federal law, and then you have common law or the court laws with what the courts have said the decisions are. So there's all these different sort of things floating out there for you. Let's move on to common law conflicts of office. When I talked about common law, that's something that the courts decide, you know, this just isn't good. And a public office is impliedly bound to exercise the powers conferred on him with the disinterested skill, zeal, and diligence, and primarily for the public. And the courts and the attorneys general have continued to use common law. Here's a good rule of thumb on common law. If it doesn't smell right, contact your agency attorney. Because if there's something in there that just doesn't seem right, do it. Most of these laws are so complex you can't rely on your gut anymore. It used to be you could say, does this make sense? Does this seem right? Does this seem wrong? These laws are so complex now, it really doesn't work that way anymore. But common law conflicts of interest are, hey, I really don't like my uncle, or I do like my uncle, and he's got an application before here. Does that seem quite right? So that's one of the things I'd suggest. And the other thing is this. Who are you going to call? Look at your agency policy. Contact the FPPC. And I will note on them, in order to get an opinion letter, it can take them up to 3 months ahead of time just to write an opinion letter or more. Sometimes they'll do a hotline that can help you, but it takes a while. Contact your agency counsel and contact your personal attorney. Now, you had a question back there? And the question is, did you happen to know what Mr. Noble did to the city of Palo Alto? And the answer to that is, no, I do not. Please, tell me.
I have no idea.
Oh, Mr. Fox, do you know off the top of your head? I haven't read the actual factual details of that case. I'm more concerned about following its legal guidance. But I could try to look that up for you really quickly. But it's always interesting. Well, when I turn this over to Mr. Fox, I'll see if I can pull it up and see what we can do.
So the next part we're going to talk about is key laws regarding perks of office. And so we're going to talk about two categories of no perks laws. One is perks that others provide public officials, and the second is advantages of office holders providing what they provide themselves, or the use of public resources. Remember, no perks laws are designed to promote ethical values, fairness, respect, trustworthiness, and responsibility. And kind of the rationale for these no perks laws is the belief that receipt of perks undermines the public's trust that decision makers are treating everyone fairly and making decisions solely in the public's interest. No perks laws bar some transactions and require disclosure of others. So the first area we're going to talk about are gifts. And so with regard to the disclosure issue, if you receive a gift from a single source with a value of $50 or more, you need to disclose the receipt of that gift. And how do you disclose that? You disclose it on your economic interest, a statement of economic interest that you fill out annually. So then there's a gift limitation. The limitation is you may not receive gifts from any one source that total over $460 per calendar year. And then the ceiling changes periodically. I believe when this law first went into effect, the ceiling was $250. So what are gifts? Well, what you'd probably expect: meals, travel payments, rebates, discounts not offered to others. So let's say you go to Best Buy or to Walmart, and they have a special for that day for everyone that comes into the store, 30% discount on flat screen TVs. That's not the kind of discount we're talking about here. We're talking about the situation where the Walmart salesperson comes up to you and says, "Hello, council member, great to see you in the store. Love to give you a 30% discount on this new flat screen television." That would be a discount that would not be offered to others. And depending on the value of that gift, and assuming it doesn't fall into the area of a bribe, but he's just trying to be really nice, you either have to disclose it, or it could actually exceed your $460 gift limitation. So what is receipt of gifts? Well, really it comes down to this. Either you have actual possession of it or you control it. So let's say if I were to give Shannon a very expensive pen, and he says, "You know what, I really don't want it, give it to Councilmember Smuckler." He controlled the pen. He controlled where it went, and therefore he actually received the gift. And if it was valued more than $50, he would have to disclose that. Except for tickets or passes, discarding does not negate receipt. Giving it to someone else does not negate receipt. So again, tickets are an exception to that rule. So let's talk about the exemptions, because I'm sure when you hear about gift restrictions, it kind of raises concerns, because we all often receive gifts from many different people during the year. So what are exempt gifts? First, gifts that are returned within 30 days of receipt. Gifts from close relatives. As we talked about, unused tickets. So if someone gives you the tickets to the rodeo and you have no interest in going to the rodeo and you throw away the tickets, that would be an exempt gift. Gifts that you donate to a nonprofit and then you do not claim the deduction. So it's a two-part. You donate and don't claim the deduction. And same thing, donate to a governmental agency and again do not claim any sort of deduction. Informational materials. Often when you go to a conference, you'll get some fancy information materials that they provide to you. Those would not be considered gifts. They'd be exempt. Personalized plaques that have a value of less than $250. Hospitality at a friend's home. A friend invites you to stay at their Aspen cabin for a week. that would be exempt. If they allowed you to stay there for a year, that might be going beyond a gift at that point. Gift exchanges for holidays or birthdays, reciprocal exchanges, for instance, lunch. You say, this time I'll buy you lunch if next time you buy me lunch. But the key thing there is making sure that it truly is reciprocal and that you're keeping track of it in case someone ever questions whether or not there is that reciprocal lunch exchange. And then inheritances. So then there are certain gifts that are entirely exempt, but you still need to disclose them. And wedding gifts are one, prizes from a bona fide competition, and some gifts of travel outside of California. So next we're going to talk about gifts to an agency. And this would be the situation where someone or an entity gives tickets or gives other either travel vouchers or the like to a public agency, and then the public agency has the ability to distribute those to public officials. And Regulation 18944.2 provides kind of the guidance on how that works. So the purpose of this is to determine if payment made to an agency for which an official receives a personal benefit is reportable as a gift. So officials do not have to report tickets as gifts if tickets given to agency for sole purpose of distributing passes or tickets to agency officials and their spouses and immediate family, and use of tickets or passes is so limited. And the key thing is that they're not earmarked for anyone. They're given to the agency, and then the agency retains a record of terms of acceptance and the method of distribution and the recipients. And it is recommended to have a written policy of how these types of gifts are distributed within the agency. But even under that rule, there is an exception that certain board members and certain executive staff may not accept travel, which includes transportation, lodging, or meals, as a gift to the agency. In such circumstances, they have to accept the gift and disclose it, and are subject to the conflicts and ethics limits. So the gift limit ramifications, if you violate the gift rules, again, we're talking about the same sort of theme. The Fair Political Practices Commission could bring a civil action, a penalty of 3 times the amount of the gift, a $5,000 fine, 6 months in jail, and potentially moving into the area of bribery and extortion, because one person's gift could be seen by another as a bribe. And so we're back to Shannon.
Thank you. Just to let you know, after I'm finished here, we're going to take a brief break, so I'm sure you'll be excited to hear that. You did have the question about the City of Noble case. I looked that up while I was sitting down there. Turns out it was a 1928 case involving the chief of police who directed his officers to pick up any unidentified bicycles that didn't appear to have owners. And they took them down to the chief of police, whether they're within the jurisdiction or outside the jurisdiction, and then the chief of police sold them. Well, there was not an ordinance from the city that said, hey, you're allowed to collect these unclaimed, abandoned bicycles or whatever the case is. And, oh, by the way, chief of police, you can't pocket that money personally. It belongs to us. And he said, no, it's mine. You don't have an ordinance that requires to get it turned over. And guess what the court said on that one? So that was, no, a public officer is impliedly bound to exercise all powers conferred on him with disinterested skill, zeal, and diligence, and primarily for the benefit of the public. And because he was seizing those bicycles for his own financial benefit, he had violated the law. So there is the factual background on that one. Now, personal advantages and perks, speaking of violating the law and how that is done. Apparently that chief of police was kind of using that for his own little perk of office, as it were, so he could have that the money come in for him. There are also constitutional prohibitions, and one of the big ones, we don't see this very often, but we want to bring it up, is travel expenses from transportation companies. They're strictly forbidden. If you get travel expenses from a transportation company, Do not take them, please. Please don't. They're strictly prohibited. It results in the immediate forfeiture of office. That can surprise a lot of people when they get back from their trip, decide to find out that they now have a lot of extra time on their hands. And it's applicable whether it's provided in connection with personal or public business. Additionally, receiving gratuities or rewards. You may not receive any kind of gratuity or reward for performing your duties of public office. So if you're performing your duties of public office, you cannot receive any kind of gratuity or reward. And the same thing with honoraria. Payments prohibited. That includes payments for speeches, articles, attending public or private conferences, meetings. And the key is officials should not use their office for private gain. Don't use your office for private gain. Now, of course, with every prohibition, there is an exception. And here is yet another exception in law for honoraria, and that is if it's part of an earned income. Payments received for rendering services in connection with a bona fide business, trade, or profession is earned income and not prohibited under the honoraria ban. An income of $500 or more still has to be reported and may disqualify you from making decision affecting that source of income. So even though there's an exception, there's also an exception to that exception. Additionally, may not use public resources for political campaign or personal use. And one of these examples is don't be using the staff that the city's paying for in order to be doing campaign stuff. Don't be using the office equipment that the city is paying for your personal campaign stuff. Don't be using office supplies. Don't be raiding the staples, the stapler, or the paper clips. Any of those sorts of things. And the same thing with regards to the facilities. Don't do it in your office. Do it in your campaign headquarters, even if that's a room in your house. Don't do it in your office. The penalty is criminal violation, jail, disqualified from holding office. And of course, there's an exception. There's always an exception, somewhat, and that's for incidental or minimal uses. Now, jumping on into expense reimbursement. That's when I was a city employee, that was something that was near and dear to my heart because I did a lot of traveling and I needed to get reimbursed a lot of times. So as part of the expense reimbursement, the general rule is officials can only be reimbursed for actual and necessary expenses. And the key words are actual and necessary expenses. And an agency must adopt a reimbursement policies that specify the kind of activities that are reimbursable. So your agency should already have a list of what is and is not reimbursable, and or what is partially reimbursable, and under what criteria they do that. A key factor is to remember, and people forget this a lot, remember your receipts. When you're traveling, they're easily misplaced. Or if you're buying something and then getting reimbursed for it, they're easily misplaced. Remember your receipts. The expenses must be documented with receipts. The local agency must use an expense report form, and these documents are public records and subject to disclosure. And we've had municipalities where every so often, maybe it's only once every couple years, they let the new kind of council members get in there, and then they do a Public Records Request Act, and they say, or they look at the documents and they say, what has our council member been spending and seeking reimbursement for, and is that an actual and necessary expense? So that's something to think about. And there's also limits on public official compensation. Not only do we have them in the state government code, but there are also charter limitations if you happen to be in a charter city. So again, local regulations, state regulations, common law regulations, federal regulations. There is regulations all over the place. Loans. There's a $250 limit. As a council member, I can turn to the person I'm working with and say, hey, I'm out of cash right now. Can you loan me $20? I need to pay for my meal here at Subway, and then I'll pay you back, when I get back to the office. It's considered a loan. There's a $250 limit. Officials cannot receive loans from those within the agency or with whom the agency contracts. Personal loans for elected officials over $500 must meet certain requirements. They must be in writing, clearly state the date, the amount, and the interest payable. They do not want elected officials, and they don't want officials pestering the employees for loans to support them. So this, if you are an employee, this is to protect you as well. So this is the sort of things that were kind of going on. And one person's loan is another person's gift or another person's bribe, depending on where you're going on these sorts of things. So it's better just to be clean. There's the $250 limit. Now again, there are exceptions to this rule, and that is bank loans or credit card debt payment while in the regular course of business, or loans with the same terms available to the public generally are not subject to this rule. So you can go out and get a home loan if you want to, and you'll be okay. The question was, well, hey, if there's a $250 limit, then why do they have the reporting limit at $500? Because there's a difference between the two limits. Why do they have it? And I can assure you, my response is, the ways of the legislature are mysterious. I have no idea why they have that particular gap. But it may be that there are also $500 reporting requirements in other ways as well. So that may be the trigger for disclosing some of those. So, but again, the legislature sets these amounts. I wish I knew. Okay, the other thing, mass mailings at a public expense. As you know, in Congress, they have what they call a franking privilege, which allows them to get their envelopes franked or marked for free shipping. They don't have to pay to send out documents to their constituents because the federal government, the post office, does not charge them. They're entitled to franking privilege. Well, if you're in a campaign mode and you have an incumbent who suddenly can use all the mailings and stuff from the city, and then you don't have that franking privilege, as it were, that puts you at a serious disadvantage. So the state said people are abusing this. They're saying we're sending out official publications. I know, heaven forbid. Can you imagine somebody abusing the process? And so what they said, well, listen, that's not fair. So we're going to put restrictions in place. And the restrictions are, if you're a public official, you can't do 200 or more items that are substantially similar in a single calendar month, paid for with public funds. There's the key word, paid for with public funds, delivered to a residence, business, employment, or P.O. box. So there's also additional restrictions. Mass mailing. You can't have any identification of your office except for the copy of your letterhead on top. No name, photograph, or reference to an official office. They can't see your smiling face as part of this, informational document that they're sending out on the public dime. And no photos on business cards. So they can still send out a few, and frankly, if you can send out 199, and you do that for a year, you can cover quite a few residences if you know how to use it. But the general rule is you can't use public funds on these sorts of things. Now, there's an exception. Of course, there's an exception. And the exception is it only refers to mailings, not websites. So even though you may have official websites, you can still have the council member's name, their face, and this sort of information on the website. In fact, if you go to the state websites, you will see the, even if it's like the, the Department of Fish and Game, you will see the picture probably of the governor, and you'll see the director for the particular office, and then you'll see the sub-regional director. All of those people are on that website, even though it's a public website. But it's not considered a mass mailing subject to these rules. Now, California Constitution also forbids gifts of public resources of funds. You can't pay for your spouses to accompany public officials. That's a gift of public funds. If you're going on a trip someplace, even though you may be reimbursed for your portion and you're bringing along your spouse, they can't be paid as part of that. You have to pay that out of pocket. Also, be careful when your agency considers a charitable contribution, even if it's completely unrelated, it seems, to everything else. Why? Because you're giving away public resources. And in order to give away public resources, certain findings need to be made. It is possible to do, but we recommend that you make the public benefit findings. Additionally, soliciting political contribution from agency employees are prohibited. Please donate to my campaign. You should never hear that as an employee. That is prohibited. except for communications to a significant segment of the public. So if they sent out a mass mailing on their own dime and it happened to be sent to your house as well, along with everyone else's house, that is okay. Now, the violation is a misdemeanor. I may have explained this before. Misdemeanors up to a year in jail, felony, more than a year in prison. And you cannot condition an employment decision on support of a person's candidacy. Gee, we'd really like to hire you here at the district or city or the county, but did you support me in the last election? Can't do that. That just makes sense. So what are the violations? Again, prison, 4 years, $5,000 per violation, restitution to the agency, so you have to disgorge a lot of these funds. Attorney's fees, not just your own, but anything spent prosecuting you can be recovered. And finally, you're barred from holding public office. So the part that you've all been waiting for, the break. Well, what I would like to do, if it's okay with you, I'd like to return at 28. That'll give us about 5 minutes. So please feel free to get up, stretch, relax, and be back in 5 minutes. Thank you so much.
All right. Well, the 5-minute break is done, so if everyone could have a seat, we'll get started again. And great. So we're in the home stretch. So I promise we're going to get you out of here at 8:05 as promised. So before I get started, Shannon just wanted to make one clarification on the loan issue.
Yes. Okay, here's the difference. $250 is from employees. $500 is from everyone else. So if you're asking for money for an employee, you're capped at $250. If you're asking money from your buddy, you can do that, but if it's over $500, it has to be in writing. Okay, hope that helps.
So we've talked about financial transparency, which was covered in parts 1 and 2, and now we're going to be discussing economic interest disclosure, which are the Form 700 forms, meeting transparency, and document transparency. So meeting transparency, of course, is the Brown Act, and then document transparency is the Public Records Act. So with regard to the Form 700, designated staff and all board members must file annually entering into and leaving Form 700. So you need to file, if you're in office or a public official, you need to file a form annually. When you leave office, you need to file one, and when you enter office, you need to file one. The determination as to who the designated employees beyond those that have been established by state law is set forth in the jurisdiction's conflict of interest code. And as stated previously, the City of Morro Bay is updating their conflict of interest code to update the positions that will be considered designated employees and therefore subject to the requirements of filling out a Form 700. So also there is a general limitation, exclusion with regard to nepotism, no nepotism. Many local agencies and cities have established their own ordinances governing nepotism and what the scope of that is. But generally, a person cannot participate in or make decisions affecting immediate family, which would include the spouse, a domestic partner, or children. So now we're going to talk about the Brown Act. And the Brown Act is the state's open meeting laws, and I'm sure many of you are very familiar with the Brown Act. And basically, it covers the meetings of a legislative body. And legislative bodies include agencies, boards of supervisors and district boards, other legislative bodies of local governmental agencies created by state or federal law, boards or commissions of local governmental agencies, and standing committees of a legislative body. So what's the intent of the Brown Act? The intent is that public agencies exist to aid in the conduct of the people's business. Actions of public agencies are to be taken openly, and deliberations must be conducted openly. All meetings of the legislative body of a local agency shall be open and public, and all persons shall be permitted to attend any meeting of the legislative body of a local agency. So basically, the idea is if you're a legislative body for a local agency, you're doing the people's business, they have a right to know what you're doing. So then, the Brown Act covers the meetings of the legislative body, so it's really critical to look carefully at what a meeting is, because it's not just the traditional noticed meeting, but it can be other things. So the definition states that a meeting is any congregation of a majority of the members of a legislative body at the same time and place to hear, discuss, and deliberate upon any items that is within the subject matter jurisdiction of the legislative body or the local agency to which it pertains. So some key terms there is a congregation of the majority. So it doesn't state a congregation of the minority. So if you have a 5-member city council and 2 members want to meet, that would not constitute necessarily a meeting under the Brown Act. But they meet to hear, discuss, or deliberate upon any item that is within the subject matter jurisdiction of the legislative body. And I think one of the critical points there is the term hear. You can be sitting with 2 other council members and you don't say a word, and if you're a council member, and they're just discussing among themselves, but because you're there and you're hearing what they have to say, you've created a majority and created a potential Brown Act violation. What are not meetings? Well, individual contacts between board members, attendance at conferences and other gatherings that are open to the public as long as the members don't discuss the business of the agency among themselves. So a classic example is if you went to the California League of Cities conference as a council member, you're sitting in one of the big plenary sessions with hundreds of other people listening to a speaker, but it so happens that 2 other council members are sitting next to you and you start talking among yourselves about what the speaker is saying and how it affects your jurisdiction. Well, suddenly you've created a meeting within that plenary session. So if you're going to those types of events, it's best to spread yourself out so that you're not creating that issue. Yes, sir.
There's a city that is within the county that is considering a Walmart. The Walmart has been negotiating with the city for many years. Very recently, the city limited their 2 council members to an update from Walmart on whether or not they would have a contract to build. Isn't that an obvious circumstance to where they are trying to avoid a Brown Act meeting for that communication that went on, and isn't that considered unethical?
Well, let me try to summarize what you just stated. There's another city within the county, Atascadero, and they are considering a potential Walmart in Atascadero, and the whole council appointed 2 members of the council to meet with Walmart.
No, they met 2-1. from what the paper says, from what the Tribune says.
And what was the purpose for the meeting if they met 2-1?
Slightest idea, because it wasn't under the Brown Act.
Okay. Well, that's tricky, and it really depends, because you can have informational sessions where a developer will meet with individual council members with a one-sided conversation about what they intend to do. But if it turns into a two-way communication between the developer, in this case Walmart, and the council members, and then Walmart is sharing with a majority what they're hearing from the council members, then you would definitely have a Brown Act violation. I would say that it's, especially in a controversial situation with a Walmart, it's kind of a precarious way of dealing with the circumstances. But it could be done legally, but we talked earlier about the issue of appearance as well, and whether or not the public perception is that that's the right thing to do. So.
Well, you made it very clear that the ethical standards are above those of the law.
Right.
So we're talking here, where is the law concerning the Brown Act on an overt meeting between elected officials and a very interested party with a lot of money that is avoiding public information on what is going on? Is there law here involved, or is there just ethics involved?
Well, there could be both. Again, I don't have all the information with regard to the Walmart circumstances and the way the meetings were set up, but you could potentially have a Brown Act violation. It depends on how those communications took place. But certainly you have the ethics standards as well. And again, as we've talked about, just because you comply with the law doesn't necessarily mean it's ethical. But unfortunately, when you're dealing with the area of ethics, the penalties aren't as clear. When you're dealing with violations of the law, the penalties are pretty clear, and we've talked about those. Attendance at social or ceremonial events, ad hoc committees, and ad hoc committees are committees established by the legislative body with a minority of the legislative body, established for a limited period of time for a limited purpose. Meetings of other agencies and committees not created by formal action of legislative body. The Brown Act does apply to collective briefings of a majority of the legislative body, and this is where we're dealing with the situation perhaps with Walmart, where they're claiming it's a briefing, but it's not a briefing of the majority, it's a briefing of the minority, and they claim that that's the basis for which they moved forward under that approach. Retreats or workshops conducted by the legislative body, informal gatherings where a business of the agency is discussed, advisory committees created by formal action of the legislative body. So that advisory committee could contain just members of the committee and of the community and no members of the legislative body. But if it was established by formal action of the legislative body, it would be subject to the Brown Act. And standing committees, which have either a continuing subject matter jurisdiction or a meeting fixed by ordinance, resolution, or formal action. Yes.
You said the Brown Act does apply to retreats or workshops?
Yes.
But then,
I can explain if it would be helpful. Let's say the council would like to do a retreat of the board of the legislative body. If it's a majority of the council that's present at this retreat, it's subject to the Brown Act. So they can't go on retreats or have strategic planning sessions in a private room with all the council present. It has to be open and public, noticed as any sort of meeting. Yeah. Serial meetings are prohibited, and we're going to talk about what those are. A series of communications by which a quorum of the body ultimately becomes involved in discussing, deliberating, or making a decision about official business. And there are usually two ways this happens. You have the chain and the hub and spoke. The chain is where member A speaks with member B, and member B speaks with member C on the same subject, and member B shares with member C what member A told member B. Suddenly, you've created this chain, and you've created potentially a violation of the Brown Act. Hub and spoke is where member A is talking to various members and sharing among the members what that person is hearing from other members. You can also create a Brown Act violation through the use of an intermediary. An agency manager speaks with member A, she later speaks with member B, and then to member C, sharing with member C, member A's and B's comments and positions. So again, that could be a city manager. It could even be a third party, such as a Walmart representative. This would be another circumstance where that could be the case. Another example is a situation where you have a circulation of a written proposal among members of the for review and signature. This could be a situation where the city manager sends something to the council and says, please review and provide comments back to me, and if necessary, provide a signature. Example also includes exchange of emails by a majority regarding issue within bodies, subject matter jurisdiction, and we'll talk a little bit more about emails because those are very precarious circumstances. Often emails are sent out by the city manager or other city staff to members of the legislative body for informational purposes only, but what can happen is one of the members of the legislative body can hit reply all and respond back to the staff member about something in the email, and then suddenly you're developing this communication among all the council members. An example of what would not be considered an intermediary situation would be a memo from the agency's attorney to individual members, which would not be a serial meeting provided no discussion by majority. So if an opinion memo went out from the city attorney to all the council members on a particular issue and did not result in responses back that created a discussion among the majority of the council, that would not be a violation of the Brown Act. So what are some rules about emails? Do not reply all to emails if you're a member of a legislative body. Do not take a position or make a commitment in your emails if they're being communicated among members of the legislative body. Email board for information only. And then the final issue is the whole issue of public versus private devices. And that's actually an issue before the California Supreme Court as to whether or not public information, such as public emails from your public email account that are contained on your private device constitute a public record that can be disclosable. The Court of Appeals up in San Jose said no, if it's on a private device, it's not a public record, but it was accepted for review by the California Supreme Court, and we're waiting for a final decision on that. Yes?
So just two quick questions. A few slides back, we talked about a board of 5, and then if you would have it, like a subcommittee of 2 can be appointed by a board of 5.
Yes.
What about, a lot of our advisory boards are more than 5. So just kind of review for folks that if you're a board of 7, the subcommittee can be a little different.
3. Right. So so long as it's a minority of the entire board, that's okay.
Is so phone records too. What's any discussion on the phone record? Because right now people are going, they have one number, right, and that number is a private. Let's say in many cases it's your private number, but you're using it for city business. So what about texting and things like that? Where does the court stand on those kinds of records? Well,
on the issue of texting using a private device for public purposes, that's the issue before the Supreme Court right now. They basically stated at the Court of Appeal level that texts or other emails on a private device did not constitute a public record and therefore were not disclosable. However, we're waiting for the Supreme Court on that. And then the other question that came up is, what if your board has more than 5 members, such as 7 members, and you want to establish an ad hoc committee? Then again, the committee needs to be of less than the majority. So in that case, it could be up to 3 members on that ad hoc committee. Yes.
The intermediary, as the hub and spoke. On the Planning Commission that some of us here are part of, we're frequently asked to come out and look at a situation that usually it's a homeowner has. So the point is to not give any advice only to receive information.
Correct. So the comment was, if you're a member of the Planning Commission and you're often asked to go and view a site and see a particular situation, whether as part of a consideration of a permit or some other issue, the key thing is, first of all, don't have a majority out there at the same time. And 2, what you're trying to do is it can be a one-way communication of information, and you can ask questions, but you shouldn't be providing any information about how you feel about the situation. So.
And one more suggestion I'd ask, if you don't mind me supplementing, John, is if you are going out there and you're making a determination on a particular CUP or entitlement or something that's out there, that's what they call a quasi-judicial decision, that you fully disclose at the hearing if you're relying on information that you learned while you were out there inspecting, reviewing the site. So everybody has the opportunity to know what information is out there.
If you viewed the site without having any contact, should you disclose that?
I would, out of an abundance of caution, because you're picking up additional information. So if you viewed the site, if you've driven by there every day on your way to work for the last 20 years, put it on the record and tell what you've also seen. For example, in code enforcement matters, sometimes they'll say, I've seen the dilapidated fence, it's over the cross, here's what it's looking like, et cetera, et cetera. John, did you have something to add to that?
Yes, I just wanted to say that we'll be talking about the distinction between legislative and quasi-judicial determinations. And if you're dealing in a quasi-judicial determination, such as approving a permit or the like, you're supposed to be basing your decision on the evidence that's presented at the hearing. So if you've gathered information independently, if you want to be able to utilize that as part of your decision-making, you should disclose it at the hearing so others have an opportunity to respond to it. And perhaps you saw something that someone else says, well, you didn't catch it on the right day or something, and they can say, oh, and just to clarify. So I've always recommended that you just disclose it on the record at the hearing so people know that you have that information.
And sometimes disclosure at the beginning, before public comment on it, so there's an opportunity to respond to those issues as well. So it's not a surprise after public comment period has been closed. Okay, the Brown Act, meeting locations. You generally must conduct a meeting within your jurisdiction. Of course, there are exceptions. There are special rules for teleconferencing. You can do it, but the stuff has to be put on the agenda early. And the city clerk, I'm sure, would really appreciate it if you let her know ahead of time if you're going to be outside the jurisdiction and appearing telephonically. And it also has to be at a site that's publicly accessible. We've actually had city council members in Wyoming go down to the only gas station within probably 40 miles so that they would be at a publicly accessible site, so that if any member of the public happened to be there, they could come in and help participate as part of that process. The Brown Act also provides for certain rights of the public, and those rights are that the public may comment on agenda items before or during the consideration of the legislative body. Time must be set aside during the regular meeting for the public to comment on any other matters under the body's jurisdiction. This is typically unscheduled communication or even sometimes scheduled communications. The public may criticize the agency and the public officials. Let me say that one more time. The public may criticize the agency and public officials. That's just part of the job. If you've been elected and you're in there, that's just what happens. The public is not required to register or identify themselves or pay fees in order to attend the public meetings. 2 items on that. Almost every single jurisdiction I've been to says, please state your name and address for the record as they walk up in order to make a public comment. You can certainly request it, but you cannot require it. So if they're not inclined to say anything, That's fine. They don't have to. However, you can take that into consideration when balancing the evidence that's being provided by this person who refuses to identify themselves or provide other such information. You can take that in consideration as part of the evidentiary balancing process. And finally, no paying any fees in order to attend a public meeting. It may seem like a really great idea to support the local baseball team by having a meeting down at the stadium, but if members of the public have to pay to get into that stadium, it's a violation of the Brown Act. Non-discriminatory facilities. Meetings may not be conducted in facilities that exclude persons on the basis of race, religion, etc. Not that they have them anymore, but they used to have clubs that would only allow men at certain country clubs. You could not hold a meeting there if they excluded women from attending those same meetings. That would be a violation. Must be accessible to disabled person, and members of the public must have access free of charge. Copy of the recording. The public may obtain a copy at cost of an existing tape recording made by the legislative body in its public sessions and listen to or view the body's original tape on a tape recorder or viewing device provided by the agency. Can I offer a word of advice? Whenever new technology comes in, there's a temptation to throw away those old clunky laserfish machines that we've had in the corner gathering dust and everything else. But unless you've transferred your records over to a viewable format under the new system, you need to be able to have that clunky laserfish machine to be able to read it. So if you're still storing your documents in one format, you've got to be able to at least have that ability to the public so they can look at those documents. So think twice before throwing out old tech. Public votes. All votes except for in the case of permissible closed session must be cast in public. And again, there can't be any secret ballots. There can't be preliminary votes that are not final or kind of secret or behind the thing. Everything must be public. And taping or broadcasting. Oftentimes you'll see people, pull up and start videotaping a council member who's saying something or a commissioner, and they'll have a look on their face or whatever the case is. They are perfectly entitled to do that. As long as they're not disrupting the proceedings, as long as they're not running for a super close-up, really close. They're fine to do that as long as they're not disrupting the proceedings. It is a public meeting. They're entitled to a public broadcasting or to record it. Now, there's various types of meetings. There's the regular meeting. I'm sure you're all familiar with the typical regular meeting. That's a 72 hours advance notice on the agenda. There's special meetings. One little caveat on special meetings, besides the fact that they can be called up to 24 hours before the hearings, is you cannot do salary adjustments or compensation paid as a fringe benefit of a local agency executive. That includes a city manager. So you can't throw a city manager contract on in a special meeting. It's got to be done as part of a regular meeting process. The other ones are emergency meetings. If you're running into a situation involving an emergency meeting, there are a lot of requirements for that. I'd highly recommend you contact your agency counsel before going down that road to make sure that you've made the appropriate findings, and of course meetings that are adjourned or have been finished. Now for regular meetings, as I said, the agenda must contain a brief description of each matter, and it must be posted within at least 72 hours prior to the meeting. And that includes, for those decisions that involve CEQA, the California Environmental Quality Act, make sure CEQA is on there. That's a really easy one to overlook. So if your decision relies on CEQA as a subpoint, you can have approval of a Class 4 categorical exemption under 15304 as one of your subpoints, followed by approval of a site plan for, 1526 Morro Bay Drive or whatever the case is. So you have both your CEQA and your underlying action as part of that. So that gives full notice because the CEQA has been on there as well. Special meetings are 24-hour notice. You must post the notices and the agenda on the internet too, and information as location is where the documents related to the agenda can be inspected. Often you'll see this across the bottom of the notice. It'll say, come into the clerk's office if you need these additional documents. Now, one of the things is, and this is tough, action may only be taken on agenda items. And one of the difficult things is we often get members of the public who start to engage in what I call topic drift. And then it usually pulls off, you know what I'm talking about, where they go off subject and it starts pulling everything else off subject, and then you start to see the attorney starting to squirm just a little bit and hoping to bring it, is it going to come back on, it's not going to come back on. The rule of thumb is if you start getting the topic drift and it's that important, set the item for the next meeting. Just agendize and set it on so that you don't have to worry about any potential Brown Act violations. That way it's open, that way it's public, that way everybody has an opportunity to engage in the process and the discussion. Now, because there are always exceptions, the agenda exception is if there is a matter that's come to the attention of the body after posting the agenda and you need to take immediate action. So there are those periods of times when something has come up literally at the last moment. And I highly recommend before you go again down that road, there's so many different requirements and things that must be fulfilled, that you contact your agency counsel, coordinate with them to make sure that all the T's are crossed, the lowercase i's are dotted, and that sort of thing. Next, here's the exception. And this is the exception to the rule, not the rule. The general rule is it's got to be an open session. However, there are closed sessions, and I know that you guys run into the closed sessions. Closed sessions can be done not only for the council, but they can also be done for the Planning Commission and for other commissions. Closed sessions are permissible, but they must fall within certain criteria, and the code has identified these safe harbor rules that appear in the government code. And prior to each closed session, what happens is there's typically announcements. They'll say, we're consideration of pending litigation involving case, blah, 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 and they won't identify the person, but they'll announce out what it's supposed to be. And each one of the closed session items has specific language for the safe harbor rules. So if you're the city clerk or a department head or you're preparing it, know that that language is involved and you can use that language for closed session. And then certain items have to be announced out after closed session. So once everybody comes back from closed session, you typically see the city attorney or the agency attorney doing an announce out of whether or not there were any reportable items that must need to be reported at that time. Here's some common closed session items. We've got personnel, public security, pending litigation. We've got labor negotiations, real property transactions. I'm just going to go through here kind of quickly just to let you know. Now, again, the violations for the remedies and sanctions, you can get court orders stopping the action. The action may be invalidated, may have to redo everything again. Court costs and attorney's fees may have to be paid. The person violating may be guilty of a misdemeanor, think up to 1 year in jail, and disclosure of closed session is prohibited. Please, please, if you're a council member or if you're a PC member, planning commissioner member, please do not disclose the confidential items that are going on inside closed session. It will make your attorney so much happier.
Okay, we're down to the final topic, and that's dealing with transparency of public documents. And we're going to deal with the Public Records Act. The basics, it's designed to give public access to information in possession of public agencies. There are limited exceptions to the production of public records, and the agency always bears the burden of justifying not disclosing documents. However, there are certain exemptions, and we'll talk about those. The definition of record is very broad. It includes writings which are defined as handwriting, typewriting, printing, photocopies, meeting tapes, faxes, drawings, maps, emails, staff reports, and critically emails, because the number of emails that are produced in any public agency are generally in the thousands, and so a request for emails can be very, very challenging. The vast majority of agency records are disclosable. And then, of course, there's documents related to public meetings, and those records are generally disclosable. Not covered employees' private papers unless they relate to the public business, computer software developed by state and local agencies, certain types of proprietary confidential information received from third parties are excluded, and that came up in the earlier session, and records not yet in existence. So if an agency gets a Public Records Act request that requests certain categories of documents that already exist and says, we want you to also provide us any of those documents that fall in that category that are generated after the date of the public records request, they can't do that. They can't ask for this continuing future request for public records. The other thing about a public record is you generally do not have to create a public record. You produce the records that you have. You don't need to create summaries of information and the like. Records exempt from disclosure. An agency may withhold records but can allow greater access if it wishes. Once a record is disclosed to one requester, whether it's for under the Public Records Act or otherwise, it must be disclosed to all who request it in the future. When is a record exempt? Again, exemptions are statutory and they're very narrow. You have the attorney-client privilege exemption. Preliminary drafts, notes, memos may be exempt depending on the circumstances. Documents containing home addresses, gun license information, addresses of certain crime victims, information regarding people that have complained to code enforcement, social security numbers, and real estate appraisals. Records concerning pending litigation, personnel, medical, and similar files protected by HIPAA and containing personal information, information technology systems security records, arrest records, investigation and security files, and then there's the catch-all exemption, which says that a record may be exempt from disclosure if the public interest in non-disclosure outweighs the public interest in disclosure. And usually that comes up in the context of employees' personal information, such as their home addresses or information about their siblings or their children, those kind of things. Generally, there's the public interest in non-disclosure outweighs the public interest in disclosure. However, as we know, under state law, employees' compensation is not protected under the public from disclosure under the Public Records Act. So with regard to responding to a request, generally if the documents are readily available and someone asks for them, you should provide them as quickly as you possibly can. If they request copies, you have an agency has up to 10 days to provide a response, but really it's supposed to be up to 10 days, not supposed to take the full 10 days if you don't have to, and then you can seek an additional 14 days to respond to the request under unusual circumstances. And again, unusual circumstances are very limited in nature, and when you inform the requester that you're going to need the 14 additional days, you need to identify the unusual circumstance that requires you the additional time. If you're going to deny a particular Public Records Act request, the denial needs to be in writing. And then finally, if you receive a Public Records Act request that really is incomprehensible or vastly overbroad, you just can't return it back and say, we don't understand, come back with something we do understand. The agency is required under the law to actually assist the requester in formulating a request that is comprehensible and that will get what the requester is seeking. With Proposition 42, compliance with the Public Records Act became a part of the California Constitution. And then under the Government Code 81008, this deals with the inspection and reproduction of statements of economic interest, and those need to be produced within 2 business days after the request for those statements. Under certain circumstances, an agency may seek a $5 retrieval fee if they have to retrieve documents that are 5 or more years old, but generally you cannot charge for the cost of compiling or researching or finding records. You can only charge for the direct cost of copying those records. So Part 4 is briefly talking about fair process, and basically this really comes up in the context of the quasi-judicial hearing where you are deciding a decision on perhaps a termination or a issuance of a permit or the revocation of a permit, and the public expects impartiality, and public expects fairness. And you should conduct the meetings objectively, follow due process, and minimal due process requires at least notice of the charges or notice of the meeting at which the matter will be considered, an opportunity to be fair, to be heard, and that the hearing is conducted in a fair and impartial manner. And again, examples are employee termination hearings, permit revocations. So with regard to the fair process, we recommend that you avoid certain missteps, appearance of bias or actual bias. Again, it's important to appear to be objective and present that to those that are involved. Of course, don't have financial interests in the decisions, personal interests that may alter your decision. Statements that your mind is made up are not appropriate for this type of hearing, and relying on evidence outside of the record is something you don't want to do. And as we discussed earlier, the recommendation is if you gather that evidence, you provide it at the hearing so that it can be considered at the hearing. As part of the fair process, too, you have a right to compete for contracts. Public contracting laws give parties an opportunity to do business on an equal basis, and therefore you have those competitive bidding requirements and requests for proposals. And in summary, laws create minimum standards for ethical conduct by public officials. The public's expectations and ethics principles create a higher standard for behavior. Remember, just because a course of action is legal doesn't mean that it is ethical or that the public or media will perceive it to be so. Ask yourself, what decision, behavior, or course of action will best promote the public's trust in my leadership and that of my agency? And then finally, as we talked about at the very beginning, there's no way in a 2-hour session that we can cover all of this material in a detailed fashion. There's much more to understand and learn. And so we encourage you to, if you have questions, to go to the FPPC website, call their ethics hotline, or speak with your agency or city attorney. And with that, we thank you very much for your attention. And we ran a little bit over, apologize for that. And I don't know if you received the quiz, but if anyone would like to stay afterwards, we can go through the quiz questions. But thanks again.